Please be seated. We'll hear argument in 21-534, the University of Texas system against the Franklin Center for Government and Public Integrity.
May it please the court. Ms. Pettit will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. This court has recognized that in the government context, the attorney-client privilege applies with, and I quote, special force because public officials are duty-bound to understand and respect the legal limits on their power. Nevertheless, the third court combined an unduly narrow reading of Rule 503A4 with an unduly broad understanding of common law waiver by publication to effectively preclude a government lawyer from using an outside consultant or investigator to look into the facts behind allegations of misconduct. In doing so, the third court deprived public officials of the advice they need to do their duty to the people of Texas when that need is at its apex. This was legal error and should be reversed. Now, the third court started in the right place when on page 12 of its opinion, it said that the linchpin of this case is whether the UT System General Counsel, Dan Sharphorn, hired Kroll & Associates for, in the words of Rule 503A4A, to assist in the rendition of professional legal services. Where it went astray is to add limitations or fail to give that are not in the rule or to fail to give that term its full meaning.
Let me ask you, whenever the investigation was originally ordered, the words were used something to the effect of, can you determine whether or not the system was above reproach, rather than specifically saying, look to see whether or not some law was violated or having to do with something more, quote, legal. What's the significance of that?
So I believe Your Honor is quoting a couple of words out of the contract. Other parts of the contract are more clearly tied to law. For example, can you please inform me if there has been a quid pro quo or a threat, which are standard crimes under the Texas law. And so as a result, there's a mix here of the purposes between potentially policy-related purposes and legal purposes. And that's really where the first error that the third court actually conducted, because they said this was policy only. But that failed to really grapple with the idea that there can be, and it creates fairly a false dichotomy, particularly in a government context where policy and law overlap so closely. And so as a result, there is a lot of debate in courts across the country on how to deal with dual purpose communications, in part because jurisdictions vary about whether they have codified their rule or whether it's by common law.
What if it only would have had, because of course we have to look at other cases when we're determining the answer to this particular case. And so let's say, what if the contract had only used that more in specific language, say above reproach? Would that include necessarily something that was, for example, illegal?
So above reproach could include something that was illegal. It could also include something that would bring the university into ill repute. So the court would need to look a little more closely at the circumstances of the privilege. And in here, we've got affidavits from Mr. Sharphorn, from Chancellor McCraven, and from Ms. Ayala, who worked for Mr. Sharphorn, that the purpose of these particular communications was the provision of legal advice. So if it was simply above reproach, a little more inquiry would be necessary. But here, the university system offered ample evidence to satisfy their prima facie burden to show this purpose. So then the only question is, if there are two potential purposes, does that defeat the privilege? And under this court, under the rules that are established in Texas, it doesn't, because the rule simply says to assist in the rendition of professional legal services, not primarily, not predominantly, and certainly not solely, as the third court seemed to imply.
When this report came back, did Sharphorn provide any legal advice after that?
Yes, Your Honor. Chancellor McCraven's affidavit in the record does say that he talked to Mr. Sharphorn about legal advice. So that's not reflected in the Kroll report itself, because the Kroll report is a publicly available document, and publishing the legal advice would waive the privilege. And so as a result, the information in the Kroll report is factual information entirely, which would not have been privileged to begin with. So
So
that,
the university's position with respect to the various documents that are referred to in the Kroll report, where there are quotations from emails, and those are all going, there's no claim of privilege associated with those.
no, Your Honor. So this case started off and it has evolved over the course of the last 7 years quite a bit, where the Franklin Center was originally asking for 625,000 pages worth of documents. Now we're arguing about 744. And so those are the ones that are privileged, and the privilege log says that they're a combination of different things. And I think that's part of where the third court also got a little confused, because it's not clear what the legal advice at issue is because some of the documents related to unrelated litigation from 2011, 2013, that time period. So there's two different issues there, and third court has conflated a couple of them. The first is whether or not Kroll was providing legal advice at all. The second is whether the documents being provided to Kroll waived the privilege because there was communication by publication, for lack of a better term, or breach of confidentiality. Those specific documents because the privilege would normally not exist over pre-existing documents, but that's not the question. The question is whether providing them to Kroll waived the privilege. Those earlier documents were privileged for other reasons and were provided to Kroll in order to understand the facts behind Regent Hall's allegations. And so that did not waive the privilege. Then there is another issue of waiver that is in one of the sort of odd statements in the third court's opinion that says that there was an intent and that the report was intended to and ultimately was made public. And it's not clear how significant that statement is in the third court's reasoning, but if it is one of its holdings, that's very concerning because it conflates two different issues. The first is what the intent of the communication was at the time, which goes to whether or not the communications were themselves privileged, and whether the publication of the report waived all of the privilege going back to for all of the things that were underlying the report. And both of those conclusions, if the third court was relying on them, are wrong, albeit for different reasons. On the intent question, as the restatement of laws has adopted, and this court has never disagreed with under, I believe, Section 71, says intent is measured at the time of the communication. And the only evidence currently in the record about intent at that time, besides the contract that we've already discussed, is the statement by Ms. Ayala in her affidavit that these were intended for the purposes of legal advice. Franklin Center had the opportunity to rebut that, and they offered no contrary evidence. So that's the only evidence of intent. The second one is whether publishing the report itself waived the privilege. Now, there is admittedly a split of authority on this topic in courts across the country into which this court has never weighed. And it's best described, I think, in a case called Kobluk, K-O-B-L-U-K, against the University of Minnesota, where the Second Circuit originally adopted a view that the publication of a report does not waive the privilege of everything that went before it because of the privilege being a privilege over communications. The Fourth Circuit, by contrast, took the position that the report would retroactively, effectively, show an intent not to have it be privileged. This court's reasonings, especially, and I would point you to In re Georgetown, are much more consistent with the Second Circuit and in the Kobluk case itself, that the communications can be privileged even if the report ultimately becomes public.
And I might agree with that, but what about statements in the report that wrote quotations from underlying documents? And to the extent that you quote from part of an email or part of an interview, is that waiver by partial disclosure? In other words, it's not the report that waived the privilege, but it was the disclosure of that underlying interview. If there's a claim of privilege associated with that, and I can't get a handle on whether there are any claims of attorney-client privilege associated with those.
Yes, Your Honor. To the best of my knowledge, there are not. Those specific documents that are quoted, and there was some discussion back and forth between the parties about whether to narrow the request to those specific documents that were reflected, and Franklin Center declined. That is at CR 70 to 74. And so
there's no claim of privilege associated with witness interviews that are then quoted in the report.
So I don't know that the witness interviews are specifically quoted. Most of the stuff that's quoted are underlying documents.
There's quotations from various admission officers, like who repeat things like, that they felt under pressure to admit certain students and things like that.
Certainly, Your Honor. So I don't know that any of because the privilege log is on a representative sample of the documents. The representative, under the TPIA, the University of Texas was entitled to send just a portion of them. I don't know that there is a claim, and the privilege log is on the materials that were in that representative sample. I am unaware of any statements in those particular documents that are on the privilege log, which is the sole basis of this lawsuit post the amendment of the complaint, that are also quoted in the report.
And you say several times in both of your briefs that it was a mistake for the third court not to do an in-camera review of those documents.
Yes, Your Honor.
You don't quite say what to do about it. It seems like you're almost inviting us to vacate and remand so that they can do that, but you don't quite say that. Tell me a little more.
So I don't think that that's necessary, Your Honor. So the trial court did do an in-camera review and concluded that they were privileged. The third court did not. Their ruling is based entirely upon a legal conclusion that is wrong for the reasons we discussed in our briefing and I've discussed today. That legal conclusion, once reversed, would completely resolve the third court issue. Now, the third court, if you were to remand to the third court, it could theoretically come up with a different reason that they were not privileged, but I don't think it's necessary to remand purely to review the documents that have already been.
If we have any doubt, and if we were to remand, would it be proper for us to direct the Court of Appeals to conduct such an in-camera review?
So this court has said it's a abuse of discretion not to order production without an in-camera review. So it would be proper for this court to direct a lower court to review the documents in camera. Again, I don't think that's necessary. The only court who's looked at them in camera has agreed with the University of Texas that they're privileged, but it would be proper for the court to do so.
On your approach to privilege in this context, would internal investigators ever not qualify as a lawyer's representative?
It depends on what the investigation was doing. So looking to the Supreme Court's case in Upjohn and a later case from the DC Circuit, which is helpful on this point, Kellogg, Brown, and Root by then Judge Kavanaugh in 2014, it's not that it's an internal investigation, it's that the facts that the investigators are going to are to facilitate the provision of legal advice. Internal investigations could, for example, in an insurance context, be entirely about policies on when they will and will not pay out. Now, those could, in theory, have legal implications, but they might not.
How would it not be something, even take that example, that when the request later on to say, well, there's no privilege, that we could not at least retroactively put into the framework of, oh yes, well, determining whether or not to pay claims, that's a legal question because we're subject to potential regulatory or litigation exposure if we don't do it correctly, and of course we want to follow the law even if we're not subject to that. I mean, how could that not be something that someone in your position in that case in the future wouldn't be able to say, well, clearly it's a lawyer's representative. It's designed to facilitate that legal analysis.
So under Rule 503A4, the first part is whether they're being employed by the lawyer themselves. And so, for example, if an actuary had asked for the investigation, they're not being employed by a lawyer, and so the rule here would not be satisfied. Then there's the question of the specific factual questions they're asking. So there's a hurricane. Was most of the damage caused by water or by wind? That is something that would, in theory, go into whether they're being paid, but it's not necessarily a legal question.
So as long as you have a situation in which the party seeking the investigation isn't so foolish as to not have a lawyer be the one in the room when this is being discussed with who you're hiring, it will always qualify as privilege.
And to the extent that Your Honor is suggesting by the term foolish that this is a pretext, we are not saying that adding a lawyer for the pure purposes of creating privilege is what's at issue here.
But it would create privilege if you have a lawyer doing any of the things you described.
If the lawyer has a legitimate, significant legal purpose, yes. If the lawyer's just there to be there in order to create a cloak of privilege, then we don't think that would qualify.
A prima facie case that's established is pretty easy to hurdle, right? So any question that an investigator would ask, as long as a lawyer was involved in retaining them, you're going to satisfy the prima facie case. And the ability to determine whether it's pretext is going to be almost impossible for a court under these standards, I would think. Am I wrong?
To a certain extent, and internal investigations of the type here, where they are investigating allegations of misconduct, it would be very likely that they would all be privileged. But in terms of more ordinary course, not so much. And that's okay, though, because as Upjohn recognized, they are trying to encourage communications to happen, and so that illegal violations don't happen.
Well,
and so,
it may not be okay because Government Code 552.022 says an investigation by or for a Texas governmental body is public information unless it's confidential under other law. So what's left of that statute under your interpretation?
So that statute covers a wide variety of investigations, including, for example, audits and police reports. So the same statute would be applicable, and that would not be touched by ours at all. Here, another statute that would have made this confidential, for example, is Education Code 51.071. And so as a result, there's just lots of different types of laws in Texas law that have investigations. And so the breadth of the statute here and doesn't quite match up with the sort of scope of the attorney-client privilege that I'm
Because a
working on.
lawyer wouldn't be involved in a police report, for example.
Correct.
But once a lawyer is involved, then
A lawyer performing a legal task, as this court looked at in In re Silver, you look to the state bar law, for example, Texas Government Code 81.101, where it is a task or such as advice that requires legal knowledge or skill. So if the lawyer is effectively acting as a business advisor or a business manager, then the attorney-client privilege wouldn't apply regardless. It is only when they are looking for facts about answering potential legal questions or legal liabilities that this is triggered.
Chief Justice, if I may,
Yes.
I just want to be clear, I understand your view on a couple factual points. One, the agreement between the system and Kroll, was that an agreement between the general counsel or the GC's office and Kroll?
So it was an agreement between UT Systems and Kroll. There is an affidavit from both McCraven and from Sharphorn himself that says that Sharphorn hired him, and I don't understand that to be in dispute. The contract itself, I believe, was signed by a business person for the university. But
Right, all right, and then second, did that agreement require Kroll to provide its report to the general counsel?
yes, Your Honor.
Okay, and then finally, when the report was done, did Kroll provide the report to the chancellor before or at the same time as it provided the report to the general counsel?
My understanding is that the general counsel saw drafts of the report before it was provided to the chancellor.
Saw drafts, but the final report went,
That's not reflected on the record, Your Honor.
okay, thank you.
Any other questions? Thank you, Ms. Pettit. We'll hear from the respondents.
May it please the court, Mr. Larson will present argument for the respondents.
May it please the court. Abraham Lincoln once asked, if you count a dog's tail as one of its legs, how many legs does a dog have? And he answered that question. The answer is 4, because saying that a dog's tail is his leg doesn't make it a dog's leg. But that's what University of Texas is doing here. They're trying to say that an independent firm hired to provide a fresh look outside of the general counsel's office is in fact an attorney representative. And they get there by comparing some aspects of what Kroll does with some aspects of what an attorney representative does. But it doesn't make the fact that both the tail and the leg are attached to the dog doesn't make them the same thing. The fact that they're both appendages, that doesn't make them the same thing. There are a number of significant differences that put this relationship completely outside that between a lawyer and an attorney's representative. if the court will indulge me, I would like to read just a short paragraph from the Kroll report itself, which I think really puts this in perspective. The court has clearly studied this very well and is no doubt aware that before Kroll issued its report, the General Counsel's office investigated this and came up short, because after that, new evidence began to emerge. Several weeks after that admissions inquiry report was finalized and issued, new information was presented to the Chancellor, and I quote from the report, "Because this information had not been provided during the admissions inquiry that concluded in May 2014, the Chancellor believed an independent firm should be retained to more thoroughly and comprehensively review the admissions process."
But could that be because the Chancellor was concerned about possible employment disputes, employment ramifications to what had happened in connection with the General Counsel's investigation, and the need to separate the investigators from university leadership?
Well, I can't.
And wouldn't that be a legal purpose for getting an outside representative to examine what happened?
I'm not aware of anything that would indicate that is in fact the case. But I think.
Well, the paragraph you're referring to might suggest otherwise.
I'm sorry?
That university leadership wasn't forthcoming in connection with all of the information associated with the admissions process.
Well,
The report seems to indicate that.
Well, with all due respect, I think what's important here is that what Kroll is coming forward and saying the purpose of the relationship is that the university has hired Kroll to provide the public with reassurance that in fact this isn't another trip through the General Counselor's office. This is, in fact, an independent firm. And this firm is issuing its report independently of the General Counsel's office for the purpose of examining the entirety of the admissions process and any undue influence, not so that the General Counsel's office it's not for the purpose of providing professional legal services, which is absolutely the core
So
of
you
what
seem
Kroll
to be-
needs to be involved in here.
Excuse me, you seem to be focusing on the independent aspect of the firm.
Yes.
Are you suggesting that anytime an entity hires an independent firm to do this kind of thing, that end of story?
No, Your Honor. I'm not suggesting that. And that would be wrong if I were to say
So
that.
then tell me because that's what I'm understanding from what you just said. So tell me where
Well, and the language Kroll uses here is interesting when they say an independent firm, because they don't say independent contractor. And I don't want to just be caught only on this. This is just one of the many aspects of this that show that, in fact, the university was at the time attempting to say, somebody else looked at this and they didn't find any problems. And now, after they get the benefit of kind of I won't say a public whitewash, but a report that absolves the university of these sorts of problems, and get the benefit of the public look of an independent firm coming in.
But even
now
if they were doing that, isn't that really the provision of legal services? Because the result of that, one way or the other, is either going to point to potential liability or not,
Well, the
right?
professional legal services, no, I don't think that's right, Your Honor, because the point of hiring Kroll has to be professional legal services, not what they do with the report afterwards. If they got the report and the report's public and the report has lots of problems about the admissions process, In fact, they make the argument that the general counsel relied on the report. But that relying on the report after the fact isn't the same as retaining Kroll for the purpose of providing professional legal services at the time that they were hired. Afterwards, yes, they can draw their conclusions and they can hire different lawyers and they can do whatever they want to in terms of pursuing it and getting professional, a lawyer or a lawyer's representative to provide professional legal services. But that's not what was being done here.
How do we know that? I mean, if there's, take a case that's not this case, and an independent firm is being hired to develop facts that lawyers, if wrongdoing is revealed, that lawyers may use then to provide advice to their client. Turns out that wrongdoing is not revealed, so we don't have any evidence one way or another about, I mean, if wrongdoing is not revealed, then a lawyer's job is pretty easy when they're advising their client, right? To say, well, yeah, there's nothing you need to do here because wrongdoing was not revealed. But what should we look to? You say look at it when they're being hired, not what they do with the results. But is it not enough to say we want you to go out and find what the facts are so that we can then advise our client on the legal ramifications of those facts?
I don't think that falls within the paradigm of providing, of being, if you hire an independent investigator.
Well, I thought you said the independent nature of it was not what you were turning your analysis on. So.
Well, it's certainly a factor, Your Honor. I think it's a large factor.
But assume,
it's not solely what I'm turning.
Okay, but assume that you can have, that a lawyer can hire in some cases an independent investigator to develop facts, and who's not a lawyer. They're there to figure out what the facts are, not what the law is, and that there are some situations where that sort of hire would fall within this rule. What's your proposed test for when it would and when it wouldn't?
Well, again, the test has to be whether or not it's for, and I guess we're kind of circling around here. So what is it that Kroll is being tasked to do that actually involves the goal of professional legal services as an attorney representative to provide to the general counsel's office at the University of Texas that they will in fact utilize in some legal capacity?
Wait, who will utilize it?
The general counsel's office,
okay,
through whom this contract is being run.
Right.
So what we have here is the contract is being run through the general counsel's office. As Justice Boyd pointed out, the contract is with the university. It's not with the counsel's office. This isn't anything like the Upjohn case. That's why I use the analogy with Abraham Lincoln's statement. To think about this, you can't just say this firm is an attorney representative. You have to prove it.
The very paragraph that you quoted to us seems to suggest that they didn't think they got enough through the internal general counsel review, so we need more, which sounds like it's a substitute for the very thing that the general counsel had done, which perforce is legal work. So why would that paragraph that you read to us not itself suggest that they actually just need to do the exact same sort of thing, but by somebody else to serve the legal work that was done internally?
With all due respect, Your Honor, I read that paragraph differently than you do.
Well, tell me why then.
I will. I mean, I'd be pleased to do that, and that was just a predicate to telling you why I think it's different. There's it's not just a do-over with a more thorough look. It's an admission, I think, that the general counsel's office is not in a position to be able to do it effectively.
But even if that's true, is it not saying that we need to have done the same thing that the general counsel's office was trying to do? And then the paragraph you quoted said, and then other things have come out. It looks like there might be more evidence. So let's just have somebody else do this who's can be single-mindedly focused on it. And maybe there are multiple motivations, one of which is, and therefore, once this happens, now having done our own report, which seemed to say it's positive, then new evidence dribbles out. Let's just put this to bed. Let's have somebody do that exact same kind of work, but make sure that nobody can ever doubt that the people who conducted it, in order to answer some of these legal questions, were doing it in a way that was wholly above board, that eliminates any doubts, that won't be subject to second guessing, et cetera, et cetera, et cetera. How is that not still functioning in the capacity of providing, assisting in the provision of legal services?
With all due respect, I don't see what the legal services are from that paragraph. An investigation is not per se a provision of professional legal services. That's clear in Texas case law. It's clear in the cases that are being cited by both sides. You have to provide evidence of what...
They want to find out if anything in the university or its people's conduct was beyond reproach, which surely includes a violation of the law. And the way to find out whether or not we violated the law, maybe we need to do things differently, et cetera, is to have an analysis of exactly what happened. How is that not doing the kind of work that facilitates legal advice, legal services, potential consequences for those who might have been, if there had been the conclusion someone had violated the law, for example?
Well, it's interesting to hear, because that particular expression of beyond legal reproach came up earlier in the questioning as indicating that the question was, how is that a provision of professional legal services to determine whether the university's actions are beyond reproach? They didn't ask if they were. It's true, beyond reproach is a very broad term, but it doesn't really have any legal import. It could include almost anything.
If something had violated Texas law, would it be beyond reproach?
Clearly. I mean, if it's a violation of law, then it would be something you could reproach the university for. But the expression, we've all hired attorney representatives in many capacities. The attorneys hire them, and the attorneys hire them to provide information that can then be utilized by the lawyer to provide legal advice. That's the point of an attorney representative providing professional legal services. That's how an attorney, in order for the attorney to provide that information.
They don't have to themselves be legal services, do they?
Say again, sir?
The attorney representative services do not themselves have to be legal services.
Right, but they allow the attorney to be able to do that. And that's what happens in Upjohn. And the point is clear in Upjohn. And in all the cases that the reason is in Upjohn, of course, they're going to prepare a report and they're going to file it with the governmental body that in order to basically get ahead of the curve, they know they've got a legal problem.
If we were to disagree with the general proposition that Kroll could not, that Kroll could be a representative, a legal representative, retained for the purpose of facilitating the rendition of legal services. If we disagree with your position on that question, do you agree that the Court of Appeals, before compelling production of the disputed documents, ought to have reviewed those documents for evidence of privilege, because the documents themselves can indicate privilege?
I'm not sure how pertinent that would be here, Justice Bland. The question is whether or not Kroll is an attorney representative. I think that's the major question, and I don't think that question's answered by reviewing the documents. But the documents themselves, that may be worthy of review in other regards. Some of those documents involve notes created by Kroll, which are not communications. You know, some of those aren't even communications. I guess I don't see how it helps the argument that Kroll is an attorney representative to go back and review the underlying documents. I haven't had that explained to me. The role of Kroll is defined by the contract, by the other evidence regarding the relationship between the parties, by Kroll, for example, stating that they had gone to talk to certain departments, certain individuals, and they were getting pushback. But that doesn't sound like, if the attorney if they're acting on behalf of the attorney and not as an independent contractor, you're not going to get that kind of pushback. This is for a professional legal services. We need you to cooperate, and this is going to be a legal matter. The kind of pushback almost indicates that they're not, that the general counsel's office is not behind it. That they're actually acting as, and you've got people out there saying, what are these people coming in and asking all these questions for? Who are they? But they were able to get that resolved. If you look at all the evidence involved, and you look at the affidavits, the affidavit just parrots the rule of evidence.
How is that different from the affidavit in DuPont?
Say again, Your Honor?
You're talking about the Ayala affidavit that just parrots the rule of evidence. That's what you're describing?
Well, I mean, it just quotes it. That's all it does.
In the DuPont case from, was it the early 90s, didn't this court take a very similar affidavit and say that that was sufficient?
And that's a very good point, Your Honor. And I think that's a very troubling point with regard to the Public Information Act.
Do we need to overrule DuPont in order for you to win?
I think you just distinguished DuPont. DuPont is a discovery case. This is a Public Information Act case.
Rule 503, you're saying that Rule 503 doesn't apply in the same way in the Public Information Act?
I think the way the court has interpreted that rule in DuPont to require for the prima facie case and then throwing the burden to the other side is simply unworkable.
Ms. Pettit pointed out that we have suggested that maybe Rule 503 applies, if it's different, it applies with even more force in this context.
And I've heard and I've read that. I've read the court has repeatedly placed a very high premium on the attorney-client privilege with regard to the government. But I would ask the court to reconsider that. There is certainly the government has no greater attorney-client privilege and should have a lesser attorney-client privilege, because the attorney-client privilege in the context of the government and the people is an impediment to limited government.
You would agree that if we do not draw the line and if we do not say that the government's attorney-client privilege is less, as you are requesting us to do, if we didn't draw that distinction and just said, no, we're applying 503, if we rule for you, that would be a substantial change in what lawyers all across Texas would be able to anticipate with respect.
I think they're two different issues. I'm out of time, but I obviously want to continue to answer the court's question. I think that what you're going to have is you've got the discovery issues, and the discovery issues are different than the Public Information Act. And there's even a litigation exception in the Public Information Act that says that you can't get stuff from governmental bodies that are in litigation, because the Public Information Act is stronger. It allows you to get more stuff, and it has fewer restrictions than discovery. The whole point of that is that it's the way the public gets to know what the government is going on. And what this court is doing is no more than an abstract exercise. If this court rules for the University of Texas, I guarantee you that every governmental body is going to start running their investigations through the counsel's office just to be able to withhold it from the public. The attorney-client privilege is not that much different than policy discussions when it comes to the government. And in terms of policy discussions, which under the exception under Rule 1.03, this court in the Dallas Morning News case v. Garland, said that there's a natural tendency among governmental bodies to read these exceptions to the widest possible extent. So, and in this particular case, the exception would become so broad as to swallow the Public Information Act. And that's what the court is contemplating here. Every governmental body is going to start running these things through its general counsel's office. All they're going to have is a counsel involved in the process, but it's not going to be professional legal services. You can read that so broadly as to be able to exclude all kinds of information from the public. I'm long out of time, and I appreciate the court's indulgence, and thank you very much for hearing me out.
Any other questions? Thank you, Mr. Larson. Ms. Pettit, you have 5 minutes.
So a lot of the discussion I just heard related to the involvement, how much involvement the general counsel's office has, and I'll go through that in some detail, but I do want to correct a slight misstatement I made earlier. The original contract was signed by the Executive Vice Chancellor for Business Affairs, but the Vice Chancellor and General Counsel assigned a number of the amendments to the contract. CR 575 is a good example of that.
Would you respond to the policy argument that if you prevail, then this is just going to give institutions a way to be able to hide information from the public?
Not at all, Your Honor. So that is it's hyperbole. To rule against us would be to discourage institutions from using investigators or third-party consultants to investigate whether there's truth behind factual allegations of misconduct.
I understand that, but I'm asking you to respond to the other part of that.
Certainly. So the question will always remain, and we have not, and I believe I discussed this with Justice Young in some extent, that we do not maintain that just having a lawyer present at these investigations is enough. If there isn't a legal question that's being asked, and this consultant is not being hired for the legitimate good faith basis of trying to assist in providing an answer to that legal question, then under our view, the attorney-client privilege still does not apply. So this is not trying to whitewash through counsel's office. Instead, what happens
and nobody, I don't hear on the benches suggesting that that's what happened here necessarily, but is he not right in saying that if we rule for you, other governmental units in the future will be able to say, all right, we now have, the map has been drawn. We need to bring a lawyer in. They need to say, as they will always be able to say for any investigation, that there is some basis for being able to benefit, to facilitate legal advice by virtue of something that has to be investigated, and therefore any governmental entity that does want to be able to conceal it from the public will be able to have a simple route to do so.
Two responses, Your Honor. First is there's a very heavy presumption in Texas law that public entities act in good faith, and that argument assumes the opposite. The second is, again, if they were to follow that act and disobey that and disprove that presumption, then the attorney-client privilege would not apply, because it wouldn't be for a good faith effort to facilitate the provision of legal services. It would be to create a veil of secrecy that's inconsistent with Texas law. So if there's a good faith, legitimate legal purpose, that is when it applies. And the only question is whether mixing that with a policy-based purpose is enough to vitiate the privilege. And under
how is a challenger going to be able to prove it wasn't in good faith?
So this is a TPIA case that has the ability for discovery. They could have, for example, attempted to depose Ms. Ayala, and they did not. That was a choice that they made. There are also this court, and I believe footnote 4 of DuPont, suggested interrogatories might be the ability to test whether or not this was for a true legal purpose. Here, the course of the conduct of these parties shows that there's no such concern. As laid out.
Under your approach, the system is the client, the general counsel is the lawyer, and Kroll is the lawyer's representative?
Yes, Your Honor.
And if all that is correct, then the report itself is a communication from the lawyer's representative to the client and would have been privileged had the system not chosen to release it?
So it probably would have been confidential and it theoretically could have been privileged. The fact that the university wrote it in such a way that was.
Do you mean
facts-
confidential under the TPIA?
Yes.
Okay, but I'm talking about the privilege. Would it have been privileged as a communication between a lawyer's representative and the client?
It could have been.
And why wouldn't it have been under your approach?
So by the time that the report was written and finalized, it could have been that there was an intent had developed to publish it. And if the intent at behind the communication was given from Kroll to the university system, that intent was to publish, then we don't maintain that's privileged.
And then I just want to be clear on your theory on how the underlying documents become communications between Kroll and the client, the lawyers representing the client, if the report itself is not.
So at the time the communications occurred, so the communications started in August. The report was developed in February. There's nothing in the record that suggests at the time the communications in August happened that there was an intent to publish. And so at that time, there was an intent to keep these confidential. Now, by the time the report
So let's say one of the underlying documents is the transcript of an interview with a professor, I don't know, whatever. How does that become a communication between Kroll and the system?
So under Rule 503A, I believe 3, the client representative would include the professor, and the representative of the lawyer would be Kroll. And under 504B1, a communication between a client representative and an attorney representative is itself privileged.
Unless it's partially disclosed.
Yes, Your Honor.
By quoting from the document.
Yes, Your Honor. And again, we don't maintain that anything that was quoted publicly remains privileged.
Okay.
Any other questions? Thank you, Ms. Pettit. Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.
Good job.